Hello and welcome to another edition of the People's Lawyer channel. Now, today is something important to me. You can tell it's important to me because I've put a shirt on. This is an emergency remedy for those home educating families, and many of them are not on the page of the Freedom and Truth movement, but they have a sense of responsibility to their own offspring and to their sons and daughters, which we need to support. And I have a remedy here, which I'm going to walk you through in a few moments, which is designed to fend off, to ward off the evil that is not just the schooling system, but its administrative offshoot, which is the local councils, authorities, and the government itself, breathing down our necks, making sure that even if our boys and girls are not in school, that they are doing the right thing and being given a so-called suitable education. That's the magic phrase. The danger specifically is in the form of the Children's Wellbeing and Schools Act. Well, it's a bill at the moment as we speak. This is May of 2025, but it will inevitably be made into legislation sometime very soon and become the Children's Wellbeing and Schools Act 2025. Now, my skin in the game is at least twofold. As well as being a freedom-friendly and family-friendly people's lawyer, I'm also the author of a book called School No Place for Children, so I am well versed in the evils of modern schooling. And let me just sum them up, those evils, in answering or by answering three key questions. Question one, what is the purpose of modern schooling? Well, my answer to that is that it is specifically designed to turn potential sovereigns into actual slaves, cannon fodder for the system. Question two, what is the generalized effect or the psychological effect of modern schooling? Well, its effect is to traumatize children, usually for life, in such a way that they never really become a full and powerful version of themselves. Schooling is, in fact, at least in my opinion, what's known as an ACE, an adverse childhood experience, and it's not on the official list. It has the same effect, the same traumatizing effect, as if a parent had died, a parent had been incarcerated, or had suffered long-term illness. It leaves a scar, an indelible mark. Although being in school is not the immediate issue, it's accounting for what you do and how you operate at home. It's a kissing cousin, really, of the schooling system. It's all part of the same tyrannical setup, and we have to be very mindful of that. The other question to ask is, what are the general implications of being in school or being surveilled as if you were in school? And in my opinion, well, I have a new 3 R's. We had the old 3 R's of reading, writing, and arithmetic, but I've postulated a new set of 3 R's, which is R for repression. And the idea is that if you're in school or if you're being over surveilled, then you can't be the fullest version of yourself. If you're being asked to do something routine, mundane, boring, not interesting, irrelevant, as we know that academic activity, if you look at the dictionary, Oxford English Dictionary, the definition of academic is of no practical use or value, which I iterate in many of my talks, and it's coming up in the remedy as well. Repression then is one of the chief R's of the modern system. The other R, or the second R, is retardation. There's nothing of value to learn. Education is more about finding out new things. It's about having true education. Real education is about having experiences and learning from them. Well, you can't have an experience from a textbook. You can't have an experience in the classroom. The experiences are just repeated over and over again for 10 to 15 years. So that's retardation. And there's no ability or no capacity or no freedom to question, to use your critical faculties, to form your own opinions. Boys and girls in classrooms now are literally having their own opinions rammed down their throat as if it was some kind of sacrilege, some kind of blasphemy. And the third R is radicalization. And I don't need to tell some of you watching this about the hypersexualization of children as young as 4 in the classroom, the pornography or the porn that is passing as sex education, and the overall atmosphere of hostility to certain traditional values. So that's a radicalization program which we need to do something about. And with that as a backdrop, let me now share the screen with my remedy. It's a form of lawful notice. So we're going to send a lawful notice, and it comes in 3 essential parts, and I've highlighted each of the main 3 parts. It starts off in the usual way, giving your postal address. But really, if you know anything about how to be a lawful practitioner, then you'll know that your address is care of, because the actual address is not owned by you. It's just a commercial postal address. So it's care of, and it's written in English, not using numbers. So if you live at number 13, it's not 13, it's THIRTEEN. And the postcode is in lowercase and in square brackets. I won't go into the reasoning behind square brackets. If you want to know more, if I say anything on this video that piques your curiosity, then I strongly suggest that you get in touch with me to do one of my courses, which will stand you in good stead and build your resilience for the future, because there's some serious nonsense coming down the pipeline. Anyway, moving on. So this is a lawful notice and offer to contract. This notice is written in plain English with no recourse to private dictionaries. In other words, we're not in legalese. We are using generally accepted English meaning and grammar and standards. Notice to agents is notice to principal. Notice to principal is notice to agents. And so that if you're writing to a low-hanging agent or agent of first response, in other words, just an employee, by giving them notice, you are giving notice to their principal, their CEO or CFO or data protection officer or whoever. 2, their full name, doing business as Chief Education Welfare Officer or whichever status they are professing. Hereafter, you or your, and that saves you from the ambiguity of writing you or your, but not having defined it. Notice upon non-consent. That's the first part. We are led to believe that the Council Education Department is interested in how we are educating our son or daughter. We appreciate that this is the result of policy change as required of the Council by virtue of the Children's Wellbeing and Schools Act 2025. Note the assumption there that it is soon to be an act. While we recognize that you may have contractual obligations and statutory duties, may we respectfully remind you that we are not contractually obligated or bound by statute in the same way unless we consent. We do not consent. So that is an important preamble, because it states in no uncertain terms that they do not have your consent. And you could add that, nor do you have our explicit consent under GDPR. That's optional. That's up to you, depending on your knowledge and comprehension. Second part, notice upon conditional acceptance of government authority. Note the power of accepting on conditions. So you're not in refusal, you're not in dishonor, and in their system, which is run on law merchant principles, they are not in common law. They're not in any law that is taught at law school. It's law merchant, Roman civil law, if you like, some kind of amalgamation between Roman civil law and British Admiralty maritime law. And the international version of it is known as Uniform Commercial Code, law merchant. It's the law that governs vessels in commerce that do shipping. And I won't go into the birth name fraud and the fact that they create a vessel, a deceased twin. Again, you need to do your due diligence to work out what is going on there. Suffice it to say that they presume to have jurisdiction over the deceased twin. And it's not just your child's deceased twin, and I use that term child loosely, but it's also your deceased twin. So the parent and child have a deceased twin over which the government presumed to have jurisdiction and authority. So I'm meeting the system halfway with this remedy. Some common law practitioners, natural law practitioners, go into zealot mode and only talk in common law or international natural law language. And I'm not doing that. I'm actually using a language which can work across various jurisdictions, in my opinion. However, we are prepared to do business with you and assist you. Remember, it is all about business. They're only interested in contracting with you and pulling you into their system so that they can continue to make a profit for the banks. This is banking. And if you need to know more about what I'm saying, please watch more videos and take more courses. Do more study if you're the independent minded type. So going back to the beginning, however, we are prepared to do business with you and assist you in fulfilling your statutory obligations upon receiving within 30 days of today's date, which is the usual GDPR courtesy or grace period, detailed and satisfactory answers to our questions set out below that are fully compliant with the fairness, lawfulness, and transparency requirements of Article 5, Section 1, Subsection A, GDPR, and Section 2, Subsection 1, Paragraph A of the Data Protection Act 2018, and that demonstrate your good faith and respect for our true position and standing at law. And here are the questions. Question 1. Do you recognize and accept our implied, inherent, and unalienable, i.e., cannot be taken away, natural freedoms as living souls, such as the unencumbered freedom and entitlement to privacy and confidentiality, free from unwarranted invasion, live in peace and be left alone when law abiding, own and hold property lawfully without trespass, have beliefs of one's own choosing, security from abuse, persecution, and tyranny? Question 2. Do you recognize and accept our express rights under the International Covenant of Civil and Political Rights 1966, specifically Part 1, Article 1, our right to self-determination, Part 3, Article 17, which says no one shall be subjected to arbitrary or unlawful interference with their privacy, family, home, or correspondence. Part 3, Article 18, 1. Everyone shall have the right to freedom of thought, conscience, and religion. 2. No one shall be subject to coercion which would impair his freedom to have or adopt a religion or belief of his choice. Remember that your belief in the power and the freedom to the power of home education and the freedom to choose it is sacrosanct, and no coercion should be directed at you to compromise that choice and that freedom. Part 3, Article 19, Paragraph 1, everyone shall have the right to hold opinions without interference. Part 3, Article 23, Paragraph 1, the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. Question 3. Do you recognize and accept our human rights as codified in the European Convention of Human Rights, Articles 8 and 9, and Human Rights 1998, Articles 8 and 9? Article 8 says right to freedom for private and family life, and Article 9 covers freedom of thought, conscience, and religion. Question 4. Do you recognize and accept the relevance of our son or daughter's rights under the United Nations Convention on the Rights of a Child, 1989? Namely, or specifically, Article 3, the right to have their best interests as a top priority. Article 5, the right to have parental rights respected with regard to what is best for them and to be able and free to guide them accordingly until they are mature enough to make their own choices. Article 8, the right to protection of identity, because there is a lot of unlawful data processing going on, biometric data being retained and used for potentially very nefarious purposes. Article 9, which applies only where school attendance is being insisted upon, the right not to be separated from parents or caregivers against their will. Article 12, the right to have their views, feelings, and wishes respected and taken seriously on all matters. The boy or girl, or your son or daughter, may specifically insist that under no circumstances must they go to school. I recently had a case of a daughter, a girl who did not even want to attend a Steiner school. That's how important it was to her to maintain her total freedom, autonomy, and integrity. Article 13, the right to freedom of expression. Article 14, the right to freedom of thought, belief, and religion. Article 15, the right to freedom of association to meet other children, join and be part of groups and organizations such as home educating community hubs, which are proliferating as we speak. Article 16, every child has the right to privacy. The law should protect the child's private, family, and home life, including protecting children from unlawful attacks that harm their reputation. Article 29, the right to an education that develops their personality, talents, and abilities to the full. And a word that is missing there could be passions. Article 31, the right to relax and play and take part in a wide range of cultural and artistic activities. In the book, School No Place for Children, I was at pains to stress how the concept of homework is an interference, is a trespass against the right to relax and play and to have your own freedom when it comes to relaxing, choosing social and leisure activities, and taking time out from organized activity simply to be yourself, whatever that means. Article 42, the right to know their rights. Question 5, are you giving us free will choice as to whether we comply with your demands or requirements to justify our decisions and submit detailed reports on our son or daughter's home-based learning? If your answer to question 5 is no, how is this not criminal exploitation according to Modern Slavery Act 2015, Section 1, as defined in Section 3, subsection 5, which says, quote, when a person is subjected to force, threats, or deception designed to induce them, it says him, but them really, to provide a service of any kind. And the service here is, of course, filling out forms, compliance, towing the line, and fulfilling criteria and justifying the paychecks of all those agents that are breathing down your necks. Upon what lawful basis would you defend such accusation of criminal exploitation? In brackets, see our conditional offer to contract below if your answer is yes, that you are offering us a choice. Question 6, do you recognize and accept the relevance of the North Carolina Superior Court ruling in Cruden versus Neal? And I won't quote the reference, that every man is independent. Well, it's 1796. It's ancient American common law. American common law is based on English common law. That every man is independent of all laws except those prescribed by nature and those man-made laws to which he has consented. Question 7. Are you claiming lawful authority over our son or daughter that supersedes our inherent and unalienable? A word on unalienable, which I omitted before, is that it's far superior to unalienable and definitely superior to inalienable. Unalienable, it does what it says on the tin. It's not lienable. In other words, cannot be surrendered. The prefix "a" means that unalienable, the prefix "a" is in legalese grammar, "a" means not. It's a negative. So not and not means double negative, which means positive, which means lienable. We're avoiding this issue by using simply one negative, unlienable. Natural freedoms as well as our statutory rights. If so, upon what lawful basis? Question 8, are you claiming proprietary interest in our son or daughter, our biological property, which I haven't included, but you could include? It's your biological property. If so, precisely which proprietary interest and upon what lawful basis? You could even add upon what lawful or legal basis. Question 9, what lawful basis under General Data Protection Regulation Article 6, subsection 1, and the 6 data protection principles as set out in Data Protection Act 2018, sections 35 to 40, are you relying upon to access, process, store, and share our personal data without our explicit consent? Question 10. Do you recognize and accept the relevance and application of the decision in Vidal Hall versus Google Inc. 2015 in the England and Wales Court of Appeal, in which it was held that data misuse alone can give rise to a claim for damages? Question 11. Do you recognize and accept the relevance and application of the decision in DPP versus Broomfield in 2002, England and Wales High Court, that there is no obligation to fill in forms without prior contract? Question 12. Do you recognize and accept the relevance and application of the US Supreme Court ruling in Clearfield Trust Company versus United States in 1942, namely that government is essentially corporate and that an agent governmental corporation requires a contract with a person, and that's your legal fiction name is the person, in order to be able to compel that person to take specific action under that contract? And I would also add, and to penalize that person for failure to take those actions, which I will add to this version that you're seeing now. Question 13. Do you recognize and accept that we have an entrenched personal conviction that home education is our unqualified and unalienable lawful right, and that any unwarranted, unreasonable, and disproportionate interference with that right and our exercise of it would potentially involve the following statutory offences and common law crimes, including but not limited to direct and or indirect discrimination under Equality Act 2010, or the equivalent if you're reading this outside of the UK, harassment under Protection from Harassment Act 1997, annoying or anxiety-inducing or distressing communication under the Communications Act 2003, threatening communication under Malicious Communications Act 1988, criminal exploitation, as hinted above, under Modern Slavery Act 2015, Fraud Act 2006, misrepresentation, which is a Section 2 offence, non-disclosure, a Section 3 offence, and abuse of authority, a Section 4 offence. And you can go down for up to 10 years for Fraud Act Section 2, 3, or 4 offences. Human rights violations under European Convention of Human Rights and Human Rights Act 1998, see above. Contravention of international conventions, also see above, such as the International Convention of Civil and Political Rights. Misconduct in public office, otherwise known as nonfeasance or misfeasance or malfeasance. Assault, trespass, malicious prosecution, and we could add defamation. The final part is notice upon conditional offer to contract without prejudice. Pending the receipt of your replies to the above questions and your providing to our satisfaction evidence of your good faith in this matter, and in order to remain in honour, which is crucial in law merchant, and to find solutions that promote peace and harmony, we shall nevertheless be willing to contract with you while reserving all our unalienable rights upon strict satisfaction of all of the following conditions. Remember, not just some of them, but all of them. A, that you provide reliable evidence of first-hand knowledge of our son or daughter and of any special educational requirements or needs that he or she may have. B, that you are capable of defining to our satisfaction and for the removal of all ambiguity precisely what you mean by education. C, that you are capable of defining to our satisfaction and for the removal of all ambiguity precisely what you mean by suitable. D, that you establish via documented evidence and independent personal testimonies, and to our satisfaction, your ability, capacity, and relevant qualifications to decide what is a suitable education in general and specifically for our son or daughter. E, that you recognize and accept that standard national curriculum aligned schooling is essentially academic in nature, and that one of the Oxford English Dictionary definitions of academic is, quote, of no practical use or value, close quotes. And that is a direct quote from the OED. F, that you recognize and accept that the Latin root of the word education, E equals out of, and ducare equals to draw, i.e. draw out of, means that education is about allowing our sons and daughters to grow as individuals, expressing and developing their innate gifts, talents, and passions. There's that word passion. Not inputting academic data simply for memorizing and testing or regurgitating at a later date. G, that you recognize and accept that people in general and children in particular learn best and thrive when they are free of stress and coercion, able to make voluntary, autonomous choices in what, how, and when they learn and at what pace. H, that you recognize and accept that ultimately all learning is self-learning and that the most effective education is self-education, inspired and freely chosen by the individual themselves. I, that you are prepared to accept and hereby agree to pay invoices to be forwarded to you in respect of our reasonable expenses for the legal administration of our son or daughter's lawful self-education at home as per the fee schedule notice itemized below. And here's the fee schedule notice. 1, filling out forms at £1,000, £1,000 in English as well, per completed page. 2, taking phone calls, answering emails or texts, etc. at £1,000 per communication. And 3, accepting pre-arranged personal visits at £10,000 per visit. We sign off by with a colon, which gives it agency and ownership. We own the content and we own the signature. In fact, autograph. We're going to autograph it in a legible way, because a scrawled signature is a sign of incompetence and illiteracy. Because if we were literate, we would write our name properly. So we're going to write our name with a middle name, if we have one, in upper and lowercase. So the first letter of each name is in uppercase and everything else lowercase, followed by a copyright symbol. And then underneath that, you can put, as you choose, living man or living woman. And underneath that, per pro, because you're writing on behalf of your deceased twin, your presumed deceased twin, the dead entity that was created or created by and therefore owned by the government. So per pro, which means on behalf of, the full legal name, but the surname, the family name, is in all caps. And that is how they designate the difference between you and your deceased twin. And that is underneath an ens legis, which is a legal entity or legal person's name. And because you have two identities, one is real and living and one is dead and fictional, that explains why we write using the royal we, the royal plural, we. You'll finish with all unalienable rights reserved, and that is the remedy, folks. You're welcome to use this and share it. It's free to air, non-copyrighted. I'm going to stop the share and come back into the land of the living. I wish you well with this. It's an important remedy. Something similar was used to get doctors and nurses off the hook during the COVID nonsense. We will await developments. It's already being used. Please let me know how you get on with it. Also, stay tuned for important updates, for more videos. Remember to subscribe to the channel. You'll find the document itself in the description box below. Subscribe, share, and you'll also find other relevant information. Just remains for me to thank you for tuning in, and we'll see you sometime soon. Bye for now.